continue to stay in United States. And these are the absolute requirement. At the time of filing the compelling circumstances EAD, you must also maintain the non-immigrant status. If you recall, at the time of COVID, there were a lot of layoffs, guys. Believe me, it was going on at that point of time. Not to the same extent as it was, not to the same long term it was, especially in April to June or July of 2020. There were a lot of layoffs going on. At the same time, what happened was that people could not even fly back to India at that point of time, Kishore. So because we had a ban in India where the flights cannot go there. So now the question comes, what do? You can't go back. You can't stay here because you're not in legal status. So of course, we use the compelling circumstances EAD at that point of time. We've been successful almost every case at that point of time. Now, USCIS has given a hint to us saying that if you get laid off, you of course have an option of 60-day grace period. And if you want to continue to stay for longer than that period of time, you can use this compelling circumstances EAD. Now, if you meet the conditions, of course, I-140 approval, maintaining non-immigrant status, you must be an H1, E1, O1, and L1 visa. You can get this 1-year permit, though. There are some cautions that I have to tell you that you must file this compelling circumstances EAD within the 60 days after you get laid off. And once you file the EAD, though, it may take anywhere between 3 months to almost 8 months under the current circumstances right now to get the EAD. While that is going on, you cannot work. That means that you have to get the EAD to work. But is your stay legal once you file the compelling circumstances EAD? The answer is yes, it is legal. You can stay in United States, but you cannot work until the EAD is approved. Then comes the question, if the compelling circumstances EAD is approved, let's say, for example, you get laid off in December, okay? And then you are going to exhaust your 60 days in February, right? And you will file a compelling circumstances EAD. And let's say you get an EAD somewhere in June, July of 2023. Let's say in August of 2023, can you, at that point of time, change the status from compelling circumstances to H1B or H4? The answer is no, you cannot. They are not telling this is a non-immigrant status. So thus by, Kishore, if you want to use once you're in compelling circumstances, you can work for a company, of course, for a period of 1 year. In that time, you can still get the H1B approval, but not change of status. That means that you get an I-797A approval. You have to take that approval to outside the country and get the stamping and come back. That is one of the minus point. Can you extend the compelling circumstances beyond 1 year? Yes, you are. Should the conditions remain the same? For example, if this time we say the condition is that, hey, we don't want to leave the country while my child is going to 7th grade in the school, we don't want to leave the country until the education is over, until June, okay? That's what you're going to say. Let's say you say that reason. Now, coming next time, you can't say the same reason. You complete to the June. Should the circumstances be the same? No, they can change. Now it can be that, hey, I don't want to sell my house under the market price. When I bought the house, it was $1 million, right? Now it's $700,000. I don't want to sell. We can use all these different reasons to extend the compelling circumstances EAD, though. We've been successful. It doesn't mean much hurdles in it, though. Many reasons, health reasons, economical reasons, if your employer desperately needs, which seems to be very rare, which they listed out as a compelling circumstance EAD, because if employer definitely needed it, why can't you file the H1B? And there are multiple, you can definitely give the reason of finances of yours because, hey, I don't want to sell my home just like that. I don't want to leave my home. I don't want to sell my car. I need to pack my bags. I need to have certain time. I've been staying rooted in this country for a period of more than 5 years. I can't just approve in 60 days. So there are many circumstances you can show to get the compelling circumstances EAD for a period of 1 year and extend it. Obviously, once, let's say, for example, if your priority date becomes current, can you keep on continuing on this and file the green card application? The answer is no. This will be a temporary solution, I would say, until you get to a stage where the economy turns around and then you file a H-1B, go to India or whichever country it is, and come back on a H-1B stamping or H-4 stamping. The good part, Kishore, in this one is that the spouse of the H-1, L-1 or O-1 or O-1, L-1 visas also get an employment authorization. And if your kid also wants to work, there are some people who have teenage kids, even they get the compelling circumstances EAD. Do we need to prove all these cases? Do we need to file for dad, mom, and child separately? No, it's one application. We file it together. You will get the employment authorization for all the people. Good, Kishore, any questions?
Thanks, Rahul. So again, are there any limitations, or in future will it impact, right? If somebody applies for this, stays, even though they're I-797, right? During filing, it might be valid, but after filing, it might get expired, the I-797.
Oh, yeah, good point. So for example, if we get laid off in December, and then let's say we are filing the compelling circumstances in January, and let's say if the I-94 expires in March, they're perfectly fine, they can stay in this country. Even though I-94 expired in March, they can stay in this country. So if the EAD gets approved, that's fine, they can stay and work. But if by any chance, of course, there's no guarantee that the EAD will be approved. Let's say the EAD get denied, then they definitely, from that period of time, the unlawful stay counts. Not from the time the I-94 expired, but from the time the compelling circumstances EAD gets denied or expired.
Will there be a 60-day period from the day, Rahul, or they should immediately?
There is no 60-day grace period if once the compelling circumstances EAD gets denied. But in general, Kishore, you have a 180-day, it's not a grace period. For example, let's say, for example, in June of 2023, compelling circumstances EAD gets denied, okay? Let's say in June of 2023. And you stay for, let's say, until July of 2023 and leave the country. Will there be any negative consequences? The rule says that if you are unlawfully present for less than 180 days, you are still eligible to get whatever non-immigrant visa that you are. Let's say in July you go and then you wait for 1 year, you apply for H-1B, you want to come back and you have stayed 30 days unlawful presence. Will they deny the visa? You're still eligible to get the visa. Now, the limit period is 180 days because once you hit 180 days of unlawful presence, then you get 3-year bar of coming back into the United States. Now, does that mean, Kishore, let's say, for example, if my compelling circumstances get EAD denied in June, will I tell people to stay until 179 day and leave the country? No, I would not recommend for them to do that thing. If somebody is staying for 30 days and leave, that seems to be reasonable. But definitely 179 days, you are really extending the limits of the law. It's not nice. You will be considered at a little bit lower rate of approval ratings when you go. But if you leave in a 30 days, that's normal. Remember, Kishore, at the time of our dear old Trump, we used to get the H-1B extensions denied. People were leaving in a month period of time. It's not they all came back on H-1B. Similar circumstances will apply here, Kishore.
Cool. Thanks, Rahul. And so you mentioned that even teenage kids, right, even though they are on H4, they will get the status, and also spouse. You mentioned that even
yes,
spouse.
that is right. That is right. When you apply the when you apply the compelling circumstances EAD, though, you would be applying for both, for the family. I mean, the entire family. You will not be applying only for one particular person.
So even though, okay, yeah, that's good. So everybody should be eligible to work, right? For example, let us say,
right. Yeah, but for example, if you don't want the child to be eligible to work, you don't have to apply for that. But child gets the status of compelling circumstances EAD, but unless the EAD is given to them, the child cannot work. So let's say, Kishore, if I get laid off, my wife doesn't want to work, I don't have to apply for EAD for her, okay? But she will still be covered and the legal status to stay along with me. Okay. But if she wants to work though, it's better to apply for her EAD separately and her EAD separately and my EAD separately. And if child want to work, you need to apply their EAD also separately.
Generally, how much it will cost, Rahul, to apply?
It will be, typically it depends on the lawyer though, somewhere between $1,000 to $2,000 is what they charge for the entire family. And of course, the filing fees for the EAD is applicable. It's approximately around $400 for the filing fees.
Yeah. And based on the current circumstances, is it approximately 6 to 8 months it is taking to get the approval?
Yeah. Previously, it used to take a long period of time, especially when we applied. When we applied in 2020, June, July, September of 2020. The reason is that at that point of time, sure, if you recall, though, there was a lot of delay in immigration at that time. COVID immigration was shut off. So there was a lot of delay at that point of time. 1 second. But now things have improved a lot. If you also recall, in 2020, EAD used to take a long time. Right now, EAD is taking a lesser time. We're expecting it anywhere between 3 months to 8 months is the time period that the EAD will be compelling circumstances. EAD will be approved. But if anybody wants to use our services, I sent a link through Attorney Ready in one of the chat though. They can use that link to fill in the information. I sent it to you in a different one though. I don't know if you got that one or not. You can pass it to the people. They can fill out a link that asks all the questions, when is your layoff, when is your I-140 approval, when is all those questions. And if they are, we will freely evaluate for them and tell them whether they fit into the criteria or not. So they can fill out that information. I send it out to you in the chat.
Right. Yeah, sure. I'll share it with everyone now. Let me, there are a few questions from the members. Let me go one by one.
Sure.
If a spouse already has a EAD from H4 visa, if the H1 primary applies for the EAD due to compelling circumstances, what happens to the EAD from her H4?
Here is one thing though. If the spouse applies for the compelling circumstances EAD, after 60 days of cessation of the employment though, the main applicant loses the H1B status, is right? Now he is on the pending compelling circumstances EAD. Since he is no longer on the H1B, she is no longer on the H4. Since she is no longer in the H4, she is not supposed to work on the EAD after the 60 days after you cease the employment. She can work until 60 days after this person loses employment, but not beyond that period of time.
You already answered this one. If compelling circumstances EAD denies after 6 months, unlawful presence from date of applied date, or is it from the denial date?
Date of the denial. Date of the denial of the compelling circumstances, not the date of cessation of the employment, not of the date of the 60-day period, not on the day of you applying the compelling circumstances, but the date of the denial of the compelling circumstances.
Can my husband's company sponsor my son's EB2 or EB3 or H1B?
Can the husband's company file EB2 or EB3? Well, husband's company is sponsoring for the child. That means that father is applying for the child. Father's company is applying for a child. There are restrictions if the family members own the company to file the green card application. It's a little bit complex though. It can be done, but it's going to go through the audit. It's going to go to a lot of different things because the owner is the father of the person, father, stepfather, whoever it might be.
What if I file the EAD within 60 days, but towards the end of 60 days, if I find a job in US, what happens in this scenario?
Good question. Now, let's say, for example, we file the EAD in January 2023. Okay. And we know that it may take up to June to get it. Okay. Let's say in the month of May, he gets a job opportunity though. Unfortunately, they cannot change the status from this one to compelling circumstances EAD pending to the H1B. They have to file a H1B. They have to leave the country and come back. They won't be allowed to change the status from compelling circumstances pending or approved to the H1B or H4.
Can we travel and come back when we are on EAD? Are we eligible for advance parole as well?
No. The compelling circumstances is more that because you're unable to leave the country, you want to stay in this country. You cannot travel while the compelling circumstances is pending. You cannot travel while you are on compelling circumstances EAD. If you travel, it's going to be one-way ticket, of course. You'll have to go outside the country, and the way to come back is definitely not compelling circumstances EAD, but H1B, H4, or L1, L2, or some other visas.
For example, if someone is on compelling circumstances EAD, can their parents travel this country? Can they?
Absolutely, they can. The parents can travel. I'm assuming that the parents will, typically they will be on a B1, B2 visa. Is that right? Can they travel into the country? Absolutely not a problem.
Yeah. What happens to the GC priority date when we move to compelling circumstances EAD? What if it becomes current when
it will remain? Right. Let's go. First thing is that, sorry, Kishore, I interrupted you. What if it becomes current and then what? I'm sorry.
Right, yeah. We'll one by one. What happens to the GC priority date when we move to this compelling circumstances EAD?
It will be as it is. It will continue with you. It will remain with you.
What if it becomes current when we are in this EAD?
When it becomes current, though, first of all, I'm assuming that you're not working for the same company that filed for it. So they will not be able to file the adjustment of status. Even if they want to file the adjustment of status for you, they cannot. Then what they can do is they have to file a H1B. You have to go outside the country and come back on H1B, and then they can file the adjustment of status. But while on compelling circumstances EAD, they cannot file the adjustment of status.
How to apply if no employer? Then to apply myself online, or I need to consult an immigration lawyer?
Well, we always recommend consult an immigration lawyer, definitely, for these kind of complex issues. But the main question is, do you need an employer to file the compelling circumstances? No. This is your application, nothing to do with employer. If employer has to file H1B, we all know. Employer has to file L1, we all know. Compelling circumstances, you do not need an employer to file it. Now, there are certain circumstances, in the compelling circumstances, they said that if the employer desperately needs this employee, okay, then they can file it. Then typically for our people who are listening to this, if the employer desperately needs it, well, why can't they file H1B, right? Now, of course, there are some people, for example, if a person is an L1A and L1B, right? And if they lose a job opportunity, they can't move to a different company, even if some company desperately needs them, is that right, Kishore? Because they must have worked for the company 1 year before coming into, which they don't meet it. And Kishore, they're not eligible for H1B because of the lottery number. Yes, they can use that compelling circumstances because the employer desperately needs this L1A, L1B guy. But for most 98% of our H1B guys, they won't meet the requirement.
And what is the percent of success or approval or denial rates?
We haven't yet faced a denial yet. But we do screen the people a little bit, though. I mean, if somebody says that my foot is paining and I want to get a compelling circumstances EAD, then we don't take the case. And we do have a free screening. I don't know if you can send it to all the people. I sent the link to you. Sure. Did you get it? I'll send it to you again.
I got it.
Yeah, we do the free screening for the people. So we go through the things, we speak with them. Hey, we don't think so we think so you meet the requirement. Now, then, even though I said, now past results are not guaranteed for the future, Kishore, there are, in 2020, the circumstances were really, really, really different. I mean, practically, how can they deny the compelling circumstances EAD when the flights these guys cannot even leave the country, right? Now, of course, things are a little bit different. But the administration at that point of time, Kishore, was Trump administration, okay? Now we have Biden administration. They, in their pursuit of the things, though, they have clearly pointed out what, hey, why don't you use this compelling circumstances EAD? So so we may get a different results now. In Trump era, we were very good because it was Modi at that point of time closing all the borders. So definitely there was no way for this guy to go outside the country. And even in those days, people were hesitant to travel at that point of time, even if Modi was elected. So now it's different. We can't use COVID as the main reason for sure, but we need to come up with the other reasons.
But overall, in Biden's administration, it is much easy, right, Rahul, compared to...
Much easy. Think about this, Kishore. Companies like Deloitte and other companies were getting 35 to 40% of their H-1B extensions denied in Trump administration. Believe me, Kishore, there was not a single day in our office. Every single day we used to get a denial. Previous to Trump administration, if there is a denial, we used to have a conference call with an employer, conference call with an employee, conference call with the employee's wife, conference call with employee's father-in-law. And when we strategize an RFP response, of course, every lawyer has their own eloquencies. And then, of course, there's a denial. The employee will say, no, because you argued this, you should have argued the other way around. It was really very touching moment for those people too. But when it comes to the Trump era, okay, got denial, okay, I'll go to India and come back. That was how. Now the administration is different. So I'm not saying it's the same thing like Obama administration, everything is approval. But nowadays, to see a denial of H-1B or anything like that is very rare. In fact, to tell you the truth, Kishore, EB-1 cases were always a thrown in, it was always a pain in our neck, okay? We didn't used to get those approvals without RFP, even before Trump. And of course, in the Trump period was different. After Trump, miracle. Now, it may not be good for Indian community, especially those people who are waiting for EB2 and EB3, because everything has been taken care by them. But yeah, denials of EB1 has also gone down significantly. So we're hoping that good results would come through with this compelling circumstances here. But obviously, if they have other options of moving to another company on H-1B, would I choose compelling circumstances here? No. Yeah, if they're considering moving to F1 visa or B2 visa, I would definitely choose compelling circumstances EAD if they meet the requirement, rather than choosing moving an F1 or a F1 or B2. Now, if they have an option of choosing the H4 EAD option, Kishore, though, and compelling circumstances EAD, I am not going with Rahul Reddy's team. I'm going with H4 EAD. Okay, it's straightforward, it's easier, and I'm going with H4 EAD. I'm not going to go with compelling circumstances EAD.
And what is the overall situation with extensions, Rahul? Is extensions also?
Extensions are doing much better. Thank to Obama administration, things are doing much better. We don't know what it's going to be when our Trump comes back again. I don't know who is going to vote for him, but anyway, that's not my jurisdiction. But yeah, right now extensions are going through very good. I'm not saying that we've never seen a denial. No, we do see a denial once in a while, but definitely not like Trump.
And is it generally 3 years, right? If they have EAD.
Right, you're right. Thanks to the IT serve, which you know that I'm one of the founder in the court litigation of Jonathan Waston, who is our colleague. Now we get the 3-year extension, no more 1-year extensions, no more 6 months extensions, no more lengthy RFPs about the end client letter, vendor letter, and the end client letter is not matching with the vendor letter, and your employer letter is not matching. We don't see that. We're good compared to now, but is it completely 100%? No, there are things there that they will do. Especially they're weeding out a lot of internal projects and a lot of prosecution is going on the fraudulent companies. But in general, good companies are doing very good.
With a layoff, can the employer cancel the I-140? What do they usually do in this scenario?
They can. I mean, typically the bigger companies, Kishore, the fan companies, Meta, and whatever companies this, they don't normally cancel the I-140. But let me tell you one thing, Kishore. Once the I-140 has been approved for more than 6 months, even if they withdraw the I-140, it will not affect your compelling circumstances EAD. It will not affect the H4 EAD. It will not affect your priority date. it will not affect you to port that date to a different company once 180 days has been passed after the I-140's approval. Now, of course, some companies withdraw it, some companies don't withdraw it. Irrespective, for most of the people, because I-140 must have been approved for more than 180 days, it will not have any negative impact for them. The only negative impact is if the I-140 that's been approved has been withdrawn within 180 days, Kishore, that's where the problem comes in.
Rahul, generally, right, if a person is on H1B and his wife is on H4 EAD, she can do any job.
Absolutely, any job. She can do multiple jobs. She can do any job. She can flip a burger in McDonald's. She can be a Microsoft CA. She cannot sell marijuana.
Right.
Okay.
So with this EAD, right, even though, for example, person A came on H1B, but now he got this compelling circumstances EAD, can he do any other thing other than the IT job? Or
absolutely, unless the compelling reasons that we have used it is for one particular profession. Let's say, for example, there is a great need for truck drivers, and this guy is a truck driver having a license, and we got the compelling EAD. We said very strongly at that point of time, we need it for the truck driving. Then this guy is doing something different, though, then it may be an issue. But in general, we are telling compelling circumstances because my kid is going to school, my wife is having some medical issues, we're having some medical issue, I'm going through some treatment, and all those things. You can do any job. You can flip a burger in McDonald's, you can be a Microsoft CEO, but no selling marijuana.
Right. Yeah. Anything legal and.
Well, that's where the problem is coming, Kishore. A lot of these younger guys, they go to Denver and they say marijuana is legal. No, it's not. That's the reason I kept on pointing out. Believe me, every week we get one case where they got stuck in marijuana.
So even though he came on H1B on IT or something, right?
IT, he can be working in a restaurant. He can do anything legal, of course.
That's good to know. How easy it is to switch back to H1B from compelling EAD?
It's definitely cannot be done here. They have to get the H1B approval and they have to go to India and come back. That's the only thing. Now, if their stamping is expired, H1B stamping is expired. Let's say, for example, if they're working, H1B stamping expired, they have to go for stamping to come back. That's the point there.
So they can go to even Canada or Mexico, right, Rahul? Or they should?
They can go to Canada. They are eligible to go to Canada and Mexico if they are open to the third country nationals at that point of time. Because remember, in the COVID period of time, they didn't allow that third country nationals. Now they are gradually allowing third country nationals. If they do allow the third country nationals, definitely they can go to Mexico or Canada and get the stamping and come back. But remember, I always speak, Kishore, there is something called automatic revalidation or Margarita switch. You can just go to Mexico and come back. That is not available for these people. Why? Because when you get the H1B while you're in compelling circumstances, you do not get the H1B with the I-94. So it's not like you go to Cancun, have a margarita, you come back on a H1B. No, that's not allowed. You have to go for stamping. You cannot go. But however, if you have the stamping valid, though, the H1B stamping valid, then there are exceptions available by going to Mexico and showing them, hey, I'm not going to be working for Microsoft. I'm going to be working with Kishore's company. Here is my H1B approval, I-797. I have the stamping. You can do that. But automatic revalidation is not generally allowed, but under limited circumstances allowed.
And once approved for EAD, can any other person in the family travel back to India?
They travel to India, but coming back is a problem. So when I say the family, so let's say, for example, you are in H1B and your wife is also in H1B. Your wife is in H1B and only you choose to go for compelling circumstances EAD, not your wife. She's not part of this package. She can travel and come back. But once she's part of the package, she cannot travel and come back. She can go one way and wait until you move to H1B and come back. One of the reasons why this compelling circumstances EAD has been created, Kishore, is that you have these compelling circumstances. You cannot leave the country for whatever reasons it might be. So when you're saying you can't leave the country, now you want to leave the country, that is contradictory to the compelling circumstances EAD.
And for especially for driving license, Rahul, one thing they need is I-94. So will this
well, you know, EAD is also an employment authorization document that will allow you to do it. But of course, there is always a lawsuit going on with some of the states like Arizona and some states. It's different issue, but most of the places will honor the employment authorization document to be eligible for you to apply for the driving license.
And also you mentioned that this need not be just for 1 year. This year they
that is right.
One reason, again next year you can show another reason.
Yeah, reasons can change, circumstances can change. First year maybe school thing, second year is market is down. I don't want to sell my home right now. I want to wait and choose for a thing. Because if I sell I can't even pay the mortgage and I'll be a burdensome. So I want to make some money, financial circumstances to pay those things. You can use those circumstances too.
The dependent children, can they continue their school studies during the period in which their EAD is not?
Absolutely. They can go to school. There's no problem at all, none whatsoever at all, Kishore. For them, even though EAD is not approved, they can go to school.
Yeah, you already answered this. Once the EAD is approved, can person on H1, H4 also work because they have EAD now?
I'm assuming that the compelling circumstances EAD we file for both the main applicant and the dependent. Once both get an EAD, of course, they can start to working.
Is there any situation where the primary may get approval, but the dependent may not get approval, Rahul? Or...
Nah, we can't imagine it because it's automatic approval for the dependent. And one other thing, Kishore, is that you can file the compelling circumstances EAD while you're speculating to get laid off. Let's say now you're thinking, okay, your company gives a notice saying that we're going to let you go in 2 months. Don't wait. You can file the compelling circumstances EAD. You can always withdraw it later on if you want to. That availability is there.
Nice. Does compelling circumstances eligible if approved H1B petition is revoked by USCIS as the candidate is working from different location rather than client location mentioned in the petition?
First of all, if you are stopped working for the company, you're not on H1B. You have only 60 days, right? So if you stop working for the company, let's say Apple got you the H1B. 60 days after Apple lets you go, you're not on H1B, period. There's nothing there. You either move to a different status, whichever changes status, compelling circumstances, or you may have filed a H4, or you may have filed a B2 or F1. You are in the change of status application at that point of time. You are not on H1B.
There may not be rejections from parallel law group, Rahul, but generally what can be the reasons for denial?
Has to see one to understand one. Have to see one. But if people come with the lame excuses, like I said, it's cold, I don't want to go to work, I don't want to go to office, I want to sit at home and work because my company called me to go to work and I want to get this EAD to work at home. We don't pick those kind of cases though, but we have to see a denial yet. Not a lot of people have explored this option though, but those people who did, they got their approvals.
Right. Yeah, many people don't know in our community. Yeah. So that's one of the reasons to have this session.
We used it very extensively in 2020, a lot of them. But then, the demand blew up so much. People are working to multiple jobs. The main question that we get from 2021 and 2022, if I have to give you, the main question we got is that, can I do 2 jobs in H1B, which you can if you file a concrete H1B. But that was the main question at that point in time. Nobody was like, I'm getting laid off. Those questions were not there. And not getting a job.
You're right. can we go from EAD to F1 or B1, B2?
No, you cannot change the status of compelling circumstances EAD to F1, B1, H1, H4, adjustment of status, A1, A2, A3, A, B, C, D, E, F, G, H, I, J, L, M, N, O, P, Q, R, S, T, U, U visas. Okay, maybe U visas you can, I don't know. That's everything you can't.
What is the prediction and take on priority date movement back to 2015 for EB2?
I will give this gentleman $5 from my side, and I want that guy to put $5. And the best way to predict the priority date, I'll give it. Let's call the parrot guy in India, okay? Give him $10, let him pick. And that guy will be much better than I am because I picked so many times wrong. It's very hard. But Kishore, here is where I think so we may be in big trouble on the priority date though. We do expected the priority date to move much faster. They wasted about 60,000 green cards in the 2021. We already know that. Now, the danger point was not about that 60,000. When it comes to the next year, we had 290,000 green cards, right, Kishore? They used up the 290,000 green cards, which was good. But what was the problem was the rest of the world, that is, rest of the world means other than Indians, though, their demand normally was 100,000. They went to 190. So we Indians normally only get our 7% out of the 140,000, which is approximately 10,000. That includes Mr. Kishore, Mrs. Kishore, and all those people. So that's only 5,000 people, right? But the unused portion of the green cards we used to get. So just like this, they invite 140 people for the buffet, okay? Only 10 Kishores are allowed. More than 10 Kishores come in, they wait. Like anybody who looks like Kishore, okay? Wait, you can't come in. Then whatever is the leftover, then anybody who looks like Kishore, you guys come in and eat. The problem now is the rest of the world is using their entire quota. And they are saying that there is going to be a backlog this year from the rest of the world. So that means that only 10% of the green cards we're going to get. And if that's going to be 10,000, in EB2, in that will be a little bit lesser. It's going to be 1/3 of that. Of course, we got some extra green cards. They have an inventory for the next 5 years to move beyond 2015 right now. That's a danger for us. Now, that's what I think so, but who knows? Maybe COVID-23 comes in. That's something it's telling that they're coming in. And all of a sudden, there'll be some more things. We don't know.
Yeah. If a person is laid off on December, but is going to be on payroll till December 31st, when does the 60-day clock starts?
The date you see is the employment, not the date you get the last paycheck. For example, if on December 1st you're done, but they're paying you for the next 6 months, the actual readings of the rule are clearly it's December 1st though. I want to take the conservative approach for the people. Yes, are there situations where we have argued it should be December 31st? Yes, we did. We're being successful in most of the time. A good number of times we're successful. Sometimes we fail. But if I were to advise a person right now, it's December 1st, I will tell him 60 days from December 1st, not December 31st.
So is the overall cost like $400 for application fee and around $2,000 for the entire family?
How much you said? We charge around $1,500, approximately around $1,500 we charge for the family.
No,
1,500 plus.
1,500 plus 400, or is it 1,500?
Yeah. No, it's not 1,500 plus 400.
No, 1,500 includes that $400 application fee.
No, 1,500 does not include the 400.
No. No. If there is a layoff and company pays 2 months severance like regular pay with the 60-day, I think you already answered it.
Yeah, it's the day severance can be paid 6 months, but doesn't mean the only purpose you are in this country is to work. If you cease to work, you're supposed to leave, but they gave a grace period for 60 days. That doesn't mean they give you severance pay. Severance pay is actually, it's a reward for what you have worked before, not what you're doing right now.
I think Vatsala got it wrong. You mentioned that we can't work with compelling EAD. What is the purpose of working from home? Yeah, they can.
Of course, you can work with compelling circumstances EAD. What I said, Vatsala, is that while the compelling circumstances EAD is pending, you cannot work. That's what I said. What I said is that with compelling circumstances, you can work as a Microsoft CEO, you can work as a flipping the burger in McDonald's. I said one other thing, what you can work out, what you cannot work is like, you can't be a drug dealer, okay? You know what I mean. So, but otherwise you're fine. If you want to flip a burger in McDonald's, you can do with compelling circumstances EAD. If you want to work as a Microsoft CEO, you can do that.
What do you mean by pending, Rahul? That means once they apply, can they start working anywhere or?
No, Kishore. Once they cross the 60 days, right? I mean, once the EAD is pending, on the pending EAD, you cannot work.
They have to get the approval and then they can start.
Yes, yes.
Can we start an LLC while on compelling status?
Yes, you can. Absolutely, you can. You can do any legal work you can do.
Do we need to go to H1B lottery after this EAD or just apply H1B?
I'm assuming that you already are counted to the H1B. I'm assuming that you already have the I-140 approval. You don't have to go to the lottery. Once you're being counted to the H1B, now this compelling circumstances EAD is also for L1s, O1s, and other people, E1s guys, okay? So for those people, they have to go to the lottery system. But the people who are moving from H1B, Kishore, to this one, they already have an I-140 approval. They don't go to the lottery system, period. Okay? Nothing to do with compelling circumstances. You can go to India for 10 years and still come back in H1B. Or can I go to 20 years to India and come back? Yes. Can I go to 90 years to India and come back on H1B again without subject to lottery? Yes. Somebody asked me 100 years. I said, no. I said, why? I don't think so. You'll be alive. And even if you are alive, you are not going to question me because I won't be there. So it has nothing to do with compelling circumstances. In general, once you have been counted to the H1B number, you have an I-140 approval, you have a tattoo on the face, okay? It's there. It can't be removed.
And what will be the EAD validity? Is it 1 year from the date applied or from the day approved?
Good question. It is from the date it's been approved, not from the day it's been applied. So if you apply in January, for example, and you get it in April, so it will be April 2023 to April 2024. And unfortunately, there is no 540-day rule extension. No, there is no premium service. There is no premium service, and the 540-day extension rule that is there for the adjustment of status EAD, and for the 540-day rule for the H4 EAD, which a lot of people know how to go to Mexico and come back and get that thing extended, is not there for this compelling circumstances EAD right now. So let's say we get the approval from April of 2023, Kishore, okay? We get until April 2024. And 6 months before, so that means that somewhere in October, we're going to file for the extension. And if the extension is not approved by April of 2024, you have to stop working.
Let's say my H1B is denied with company A, but I have a valid visa with company B. I did not have company B at the time of visa denial, but my I-94 is valid with company B. Do I get a 60-day rule as soon as my visa is denied with company A?
The transfer of, yes, you do have a 60-day rule here too. But here is my issue with this gentleman though. Remember, Kishore, I told you that if the H1B option is there, I don't like to choose the compelling circumstances EAD. Now, if the H1B transfer is denied, though, we have used the 60-day rule and filed the company B's H1B again and got it approved. So I would want this guy to use the H1B again rather than compelling circumstances EAD. But he's right. If the H1B get denied, you have 60 days to file a compelling circumstances, you can. But I prefer to file a H1B for him. These are the things we screen when we are putting a notice on there. We tell them, no, people have H4 EAD option. Why do you need this? You go for that one, okay? People have the H1B option, go for it. Those are better options. This is only when you don't have a job, you don't have an option for H4 EAD, compelling circumstances is better. Not if you have a H1B option, not if you have the H4 EAD option.
One last question. I have a H1B through non-profit. I-140 is approved. If I go through compelling circumstances and getting back on H1B, will I require to enter lottery?
Yeah, he has to. He has to enter the lottery. He has to enter the lottery. The reason is that I told you that the two things has to happen. He must have been counted toward the H1B number, which he was never. So he has to go to the lottery. But in general, people like Tom, Dick, and Harry, like you and me, working for, let's say, Tom, small consulting companies, let's say big companies, so they don't have to. But for the people who are working for universities, they can still be eligible because I-140 is approved. But unfortunately, he has to go to the lottery. The other option is go join another nonprofit higher education institution.
My H1B is approved in premium, but spouse H4 is not yet approved. Can I apply for H4 EAD with H1 approval, or should I wait for H4 approval?
First of all, I don't know why you did not apply the EAD along with the H4. You can definitely apply for the H4 EAD. And there is if our H4 EAD is not expired and you're filing an extension, there are things where your wife can go to Mexico and get the H4 extension though. I want him to read something, a video we put on. You need to type in 540-day H4 extension, Reddy and Newman. Type it in the YouTube. You have a very good thing where you can go to Mexico and extend it instead of going through any other methods.
Yeah, there is one long question. I am in L1A with I-140 approved with 2019 priority date through company A. My H1B, which was filed by company B, got approved today. I was told by employer B that they applied my change of status as well. It was processed in regular. My new employer is yet to receive the approved H1B petition. Should I wait until my new employer shares me the soft copy of new H1B approval copy in order for me to resign from the current employer?
Yeah, I would recommend to wait for it until he resigns from the company, because who knows if that comes without the I-94. But if he gets the premium processing approval and they forwards it, I will resign.
And when can I travel to India for stamping? Am I eligible for Dropbox since I had a valid visa earlier?
Absolutely, he can travel. I would recommend if he moves to H1B, just wait for 1 month or 2 months before traveling. It's not mandatory, but I would recommend, because you always need to get a visa there too. Yeah, he's eligible for Dropbox. Almost everybody is eligible for Dropbox, whoever got their visa stamped. Now, 99% of the people, though, not 1% is always there.
Yeah. But because he had L1 earlier and now it is H1?
That is right. Even though it's a change of status from L1 to H1B, they're eligible for Dropbox. F1 to H1, eligible for Dropbox. H4 to H1, eligible to Dropbox. Only until December 31st of 2000, I think so, it's not December 31st, maybe September 30th of 2023. Sorry about that.
Do you have any consequences during the future visa interviews at consulate after utilizing this compelling circumstances EAD?
No, it's completely legal. There is nothing wrong with it. No negative consequences for it. No negative consequences. We don't expect anything.
Yeah, there are a lot of other questions which are not related to compelling circumstances topic, and also it is 8 Central. So again, yeah, there are many members asking for Rahul's information. Now let me share the screen.
Yeah, can you give give the link, and we do free evaluations for the people.
Right.
Instead of website, can you give them the link that I gave it to you though?
Yeah, I shared that, Rahul.
You can click on the link and then you can show them the link if you can. That will be easier. If you copy and paste it exactly, it will come there.
Do you want me to copy this one or?
Copy the link that I gave it to you and paste it.
Okay.
And they will see that you can fill out the information, your name, email address. You have the link, is right? I gave it to you, right? Should I give it to you again, Kishore?
Yeah.
I'll give it to you again. 1 second.
Yeah, I have it.
Yeah, that's the one. If you can scroll down a little bit. No, that's not the one. You give the wrong link. You did not copy the entire thing though.
No.
You when you pasted though, you didn't paste the entire thing. You pasted from half. Yeah, now you paste it. No, that's the link. This is compelling circumstances. So it asks you the name, it asks you all those things. So we'll get the information and we'll screen it and we'll speak with you to see if you're eligible, if you're not. For example, if you got laid off like 6 months ago, we tell you, sorry, we can't help you. So this is, you can fill this information and we will contact you.
Okay.
This link is provided to you guys by in the chat by Kishore.
I'm sharing that link. Thanks a lot, Rahul, for taking time and
Thank you.
Yeah, sharing all the information related to this.
Yeah, don't forget on December 31st, Kishore is hosting a big party. You guys are all invited. I'll be there
Right. Yeah, I'll meet there. Thanks, Rahul. See you on 31st.
See you. Thank you, guys. Have a Merry Christmas and wish you best of luck. Bye.
Good night, everyone.